I am delighted to welcome you on behalf of Lawyers Defending American Democracy. I am Peggy Quince, a member of the board of LDAD and a former Chief Justice of the Florida Supreme Court. My other role within LDAD is as co-chair of the Working Group on Judicial Independence and Attacks on the Judiciary, while I have the great pleasure of co-chairing with Roz Richter, a former Associate Justice of the New York Appellate Division of the Supreme Court. LDAD is deeply grateful to Roz for her work conceiving of and putting together this great group. LDAD was founded in early 2019 to help galvanize the legal profession to do more to protect democracy and the rule of law. Today, the threats to our democratic institutions, our judicial system, and our judges have grown increasingly dangerous and threaten to undermine public confidence in this critical third branch of government. It is therefore critical that everyone, and particularly lawyers who take an oath to protect the rule of law, be participants in the fight to protect our democratic institutions and the principles and norms of democracy. This is the challenge of our lifetime, and we hope all of you will join us. We actively engage volunteers in our work and encourage you to visit our website to learn more, particularly about Meeting the Moment initiative. Today, I have the honor and pleasure of introducing to you our distinguished panelists for this important conversation. Catherine Christian Esquire, the moderator for today's program, is a partner at the firm of Liston, Abramson, as well as a legal analyst for MS Now and NBC News. She is a highly experienced trial lawyer and advocate with more than 30 years of public service in the Manhattan District Attorney's Office. A prominent leader within the New York legal community, Diane has received numerous awards for her professional and pro bono contributions. Judge Nancy Gertner is a retired federal judge appointed to the United States District Court by President Clinton in 1994. She served on the court until 2011, when she retired to join the faculty at Harvard Law School, where she now is a senior lecturer in law. The recipient of numerous awards, Judge Gertner writes and speaks widely on a variety of legal issues, with a more recent focus on the rule of law. Her opinion pieces appear in publications such as the Boston Globe and the New York Times. Her forthcoming book, Incomplete Sentences, is a retrospective on her time on the bench, examining her personal experience of sentencing human beings. Judge Diane Kiesel is a retired judge of the New York Supreme Court who spent nearly 25 years presiding over criminal cases. She began her professional life as a journalist, including time in Washington, D.C., and is the author of 2 books. She Can Bring Us Home, Dr. Dorothy Boulding Farabee, Civil Rights Pioneer, and When Charlie Met Joan, The Tragedy of the Chaplain Trials and the Failings of American law. She teaches domestic violence law at New York Law School and has authored several editions of a textbook on domestic violence law and is a frequent contributor to CNN and MS Now. Of course, these brief introductions do not fully cover the extraordinary achievements of our panel, and I encourage you to learn more about each of these remarkable women. It is now my pleasure to turn the program over to Catherine.
Thank you, Judge. And my apologies. I am on my phone because the way life works, the internet in my office went down 2 hours ago and it's still come up. So I'm operating on 5G. And if I somehow disappear, Judge Richter, who I clerked for many moons ago, I'm sure will just pop in and take over. Is there a slide up of the posting? When you're on your phone, it also makes it difficult to see.
Yeah, there's a slide up.
Okay, great. I'll give everyone an opportunity to read that. Many of you who are here, and we thank you, have probably seen it or variations of it. Okay, so we'll take it down. Today's panel, and I just want to add to what Judge Kiesel said about this organization, Lawyers Defending Democracy. We all know, and read it many years ago, the line, the first thing we do, let's kill all the lawyers. And we know that what Shakespeare was really saying and what he realized is that when you get rid of the lawyers in a democracy, that's the first step in becoming an authoritarian form of government. So in this world that we have of executive orders against law firms and attacks on the judiciary, a lot of it on social media, and whether or not you are a subscriber to Twitter, Blue Sky, Truth Social, whatever, you're going to see social media posts. It's going to be reported in your newspaper, it's going to be reported on your TV. So I'm going to start actually with Judge Gertner because I pulled up, you write a lot of op-eds. And if anyone is saying, how come these judges are getting to speak out publicly? They are all happily retired from the bench, but still they're not retired from life. So Judge Gertner, you in the New York Times essay you did with Steve Vladeck this summer, after the Attorney General of the United States on social media posted that the Department of Justice, filed a complaint of judicial misconduct against a judge who spoke at a closed judicial conference. The title of that essay was "This Attack on Federal Judge is Preposterous." So jumping off from that, many people see that what's been happening now in this current climate, the comments, the postings, the tweets about pending cases, possible cases, directly attacking judges. What do you have to say about that? Is the climate very different than it was even under the first administration of this current administration?
Oh, there's no question that it's different. It's different in two respects. One is the vitriol of the attacks on judges. And the vitriol sort of makes one, puts a commentator in a difficult situation because you don't want to respond with vitriol to vitriol. You don't want to sort of completely, sort of fan the flames and make things worse. But the vitriol of the attacks is like nothing I have ever seen. And that is directed, in one sense, it's directed not at a particular judge, but it really is directed at all judges, because all judges have been making rulings that the current administration doesn't like. So I think one is that the content is certainly much more vitriolic than it ever has been, and of course the amount is totally different. It's not like you're responding to a single editorial in a particular paper. You are responding to an editorial that is then retweeted and reposted all over the place. So the underlying truthfulness of it, or the lack of truthfulness, becomes very difficult to trace. I felt compelled to respond to the Boasberg complaint because headlines, this was the complaint against Judge Boasberg, ostensibly for saying something at a judicial conference, which suggested that he believed that this administration was not going to obey the law. And the more that it is retweeted, the more that it is said again. It's like the game of telephone when we were children. By the time you have said it 9,000 times, the original meaning was gone. And we thought it was really important to say what the original meaning was, which is they misquoted this judge. The setting was in a breakfast meeting where the chief judge says, "Tell me what your courts are thinking about." And Judge Boasberg said, "My court is worried about blah, 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 not I personally." And even if he had said what was quoted, it wasn't improper. So I thought it was terribly important to correct the record in the same setting that the record was being undermined.
Setting the record. Now, how does, whether it's Judge Boasberg or any other judge who has the misfortune of being on the end of an attack, whether it's posted up, whether it's a frivolous complaint to the Commission on Conduct for federal judges, or if you're a state judge, whatever your jurisdiction's Commission of Judicial Conduct is. And
well, but that is the problem. I mean, the problem is that sitting judges cannot defend themselves. Sitting judges can only defend themselves when others step in and say, "Here's what's going on." Courts do not have press offices, although I have been calling for that for years, and I think it's especially something that you need to have now. It's almost as if when I left the bench in 2011, from 1994 when I was a judge to 2011 when I left, you could presume, the people would presume the legitimacy of judging. There were attacks on a particular case or a particular decision, but the overall sense was that people assumed that you were doing the right thing and you were implementing the rule of law. I think that that's been under such attack that I think judges now have to justify what they do, justify it either through the language of others, they don't have to, through their own opinions. They can do it through their own opinions. I think that others should step out and say what they did was correct or appropriate. But I think we have to do more because the attacks are much more substantial.
I think the place where there can be some pushback is on the administrative level. Certainly, administrative judges can issue statements reaffirming the legitimacy, if you will, of decision making, saying things like, "You may not agree with Judge so-and-so's opinion. However, attacking the judge personally or the judge's politics or who appointed the judge is not the appropriate way to address a judge who's said something you don't agree with." We all know what the appropriate way is, and that is to appeal any decision in which a particular party hasn't prevailed.
And following up on that, Judge Kiesel, how does a judge, with getting these attacks, remain impartial and without naming a case? And I think you know what I'm talking about. If you have particularly, I don't know whether it was a prosecutor, defense attorney who makes public statements or makes a filing that sort of questions or puts a judge in a bad position, how do you maintain that impartiality and just do your job?
Well, it's sort of, as Harry Truman said, if you can't stand the heat, get out of the kitchen. I mean, judges are trained to ignore the noise, if you will. Now, it's hard. We're human beings. But when you see either newspaper articles questioning a particular ruling or challenging your objectivity, I think you simply have to put your head down and do the best that you can to ignore it.
I agree. I think that the way Judge Kiesel described it is exactly right. The nature of the job is to try to deal with all of the pressures of judging. The newspaper article that you read the day before that you shouldn't have read, but that in fact is talking about the case. The lawyer that annoys you by his presentation, and you have to sort of separate out the wheat from the chaff. I mean, the job of judging is to struggle with external influences, to struggle with internal biases. And I think that the social media stuff is part of that. I think that the struggle is what judges are, trained to deal with.
Now, judges are only human, and I'm thinking of a particular instance of in New York, in Manhattan in particular, a Judge Merchan, who was the presiding judge over the criminal case against President Trump last year. He, in particularly, and his daughter were publicly attacked, social media and publicly. How does a judge deal with that? And I don't think either of you had that personal experience, but if you have, could you speak to it? But how generally would a judge deal with that?
I think, I'm sorry.
No, you go.
I think that, first of all, he handled himself with class and grace. No matter how many attacks he was getting outside in that hallway every single day in recesses, he completely ignored them and again put his head down and did the work. I think the rest of us assisted him, however. As Judge Gertner said, those of us who are no longer on the bench, we have our speaking rights back, if you will. And I know that during that trial, there were many, many former judges who appeared on various news shows. And I certainly made it a point, and I know my other former colleagues did as well, to remind viewers that this judge was behaving appropriately. He was not corrupt. He was ruling based on the facts. And we were sort of able to hopefully at least get a message out that he couldn't get out himself.
And I mean, then if you recall, there were issues with respect to controlling the conduct of the lawyers on the case and controlling the conduct of the defendant. That goes not so much to, I don't care what they say about me, but it goes to, is what they're saying going to impact the jury? And he had to walk a very difficult line, admonishing the lawyers, admonishing the defendant, which was then President Trump before he became president a second time, that they can't speak knowing when they know that their speech will have an impact on the body that is adjudicating the case. In other words, speaking in a way that the jury could be affected by. That was not easy for him to do. He had to walk a fine line about sort of making that order and then understanding that, thinking about what he would do if the lawyers or the defendant disobeyed it. I think that what we all recall is that certainly President Trump walked up very close to the line. If he didn't put his toe over it, but at least he walked very close to the line. So there are ways of controlling the impact of the noise on the jury. And then we've been talking about the ways of controlling the impact of the noise on the judge.
Well, speaking of jurors, and I'm talking also about grand jurors and the trial jurors, how both of you tried a number of cases, you've presided over a number of trials. What are the concerns you have about these posts, about, these attacks on the judges, the attacks on the quality of a pending case, have on prospective grand jurors, prospective jurors?
Gertner,
You should go.
Okay. Well, first of all, judges are presumed to follow the instruction. Jurors are presumed to follow the instructions of a judge, right? So what you do all the time is remind jurors they are not to read anything about the case. They are all of their decision making has to be based on the evidence they hear inside the courtroom. The problem is that over the years, and particularly in the current administration, it goes beyond just newspaper articles or television reporting about what has happened inside the courtroom. It's direct lobbying, if you will, through social media. So I have found over the years when I was instructing a jury that my list of things they couldn't watch, listen to has, grew and grew and grew as time went on. Stay away from, social media. Stay away from, don't post. And then the other problem is, and then I'll turn the floor over to Judge Gertner, jurors themselves then have to be admonished not to be retweeting this, not to be talking about this, not to be bragging about their jury service. There are all these factors that play against being able to keep this work within the courtroom.
I also think, I remember when it was quaint to tell the jury, don't read anything about the case. And you had this image of a juror with a newspaper where her husband has cut out the article about the case, and she lifts it up and suddenly there's a hole in the middle of it. Well, that is actually harder to do today. You go on an internet search engine and suddenly the news is everywhere. So even sort of being in the world in any way what means that you're going to be assaulted with the news. It takes an enormous amount of intentionality to cut that off, much more than before. But I mean, we have to hope that jurors will do that and listen to these two instructions. I mean, I have to admit that when I had been a trial lawyer before I went on the bench, and I remember I was a cynical trial lawyer, who believed, of course, jurors never listen to the instructions of judges. And then when I went on the bench and people would come up to me in the morning and say, Judge, I was on the train and I accidentally saw this headline, and you realize that people were trying. And it was really quite extraordinary. The trying is harder in a social media world than it had been before. And it certainly is, there's a generational gap. I think that those of us on this call have an easier time shutting off the internet than my kids' generation.
This raises another interesting issue. Over the years, since I started out as a trial lawyer and then moved to be a judge, early on, you were sequestered all the time for the most, a burglary case, you'd end up sequestering a jury. We have to ask ourselves, are we going to get to a point where we're going to have to start sequestering jurors again? Because that trajectory changed over the years. And we don't really sequester anymore, except in the most extraordinary instances when there have been threats. It's expensive to sequester. It prevents people from wanting to serve on juries. That may be something we have to look at.
But would there have to come a point where phones are taken away from sitting jurors? Because if everyone has a phone, and you get breaking news alerts, or people scroll, even if they're given the instructions, don't read this, you're sitting there and then poof, here's your breaking news alert. Particularly if it's a high profile case. What do we think judges realistically can do in this world where everyone has a phone? You go in an elevator and sometimes you get breaking news alerts depending
on the screen, right?
Right. Oh, yeah, on the elevator screen.
Right. I mean, I think that the way the Supreme Court has dealt with that up until now is to pretend it doesn't exist. This wonderful way that only the Supreme Court can do is to say, don't worry, even though there was an enormous amount of publicity, we think everyone managed to deal with it, weren't paying attention. So there's a little bit of a false consciousness there. I think that the best you can do is to admonish people not to pay attention to that, not to seek it out, and then admonish them that what you're seeing on the screen in the elevator is not evidence. What you're getting on the social media post is not evidence. It's asking a lot of jurors, but that's what we have to do. Taking the phone away, I think, would have I would have jurors who would have a coronary if we did that.
Probably.
You know, and I know that I would too. So, but I do think, I mean, I think that if you can't totally inoculate a jury from social media, then you have to explain trial truth and social media truth are not the same things.
Do you think a judge could obviously not take away the phone, not read the news, but can a judge say during the pendency of this trial, do not look at TikTok, Instagram, or Facebook, or Truth Social, and et cetera, whatever those social media apps are?
I think that what you're doing is they shouldn't affirmatively reach for those.
Mm-hmm.
It's very difficult to stop the assault in the elevator of the news, but I think you could certainly say to them, don't reach for.
I agree. But the problem is there's so much that's outside of the judge's control, as Judge Gertner just pointed out.
Right.
And, is it even realistic? I mean, would we ever have, I guess there are people who actually have never looked at social media, but that doesn't mean they're not going to see the post thing because they saw it some other way, or their friend handed the phone to them and say, look what this person just posted.
It's very interesting. I remember when I was a trial lawyer, and you were interviewing jurors and you were talking about newspapers. These were the good old days when you're talking about newspapers. And you'd say, in an incredibly high profile case, have you read, seen, or heard anything about the case? And the person would say, absolutely not. And you knew that everyone in the galaxy had read, seen, or heard about the case. You knew you had some serious concerns that this person wasn't telling you the truth, because it was such a high profile case. So if you have someone who gets on the stand and says, I don't get on the internet, I don't go on social media, I live in a tree, I'm not sure the lawyers will want to select that person in the first place.
True.
Now we know, and we've all heard about the gag orders, which are judges can limit what the parties, the lawyers who appear before them, can publicly say about a case. Can a judge issue an order prohibiting someone who is not a party in the case from posting or writing about it? I'm thinking there are trial junkies who like to go watch trials or who watch it on, court TV. If they decide they're going to write a blog about how horrible the facts of a case are, the judge or the defense or the prosecutors. Is there anything a judge can do about that?
I think that you've got to work it through the back door and do it through the jurors. If somebody is a trial junkie writing a blog, I think
it's 5 o'clock.
Once again, you've got to tell the jurors, it's come to my attention that there has been some postings about this particular case. I instruct you not to look at them, not to read them, not to be influenced by them. There is a part of me, though, that thinks this is, look, a legitimate worry. But in my experience, 25 years on the bench, jurors listen to judges. At least they have up until, very recently when we've been attacked in all kinds of new and unique ways. But there used to be so much respect, at least for judges, that if you told somebody not to do something, I always felt pretty confident they were listening to me. There'd be an outlier every now and again, and it would come back and bite you. But for the most part, I'd like to think there's still that respect, some level of it. What do you think, Judge Gertner?
No, I think that's true. There's something about the solemnity of the courtroom. There's something about the oath. There's something about the flag behind you and you being in robes that, at least in my experience, changes the way people relate to facts. I was very troubled during COVID that so much was being done on Zoom. Mm-hmm. And you have a different relationship to the case when you're sitting in your bedroom in your pajamas looking at the screen than when you are in the courtroom with all the solemnity and formality of the courtroom. So, I think that may be the best we can do. And that, that there may not be a perfect solution, but admonishing jurors that this is different that the decision-making that takes place in the four corners of a courtroom is different kind of decision-making that takes place in their home or on the street. The kind of evidence is different, and the things that matter are different, and they are under oath. And I think that that affects them.
Lawyers, particularly ones who usually go to court and with the Law and Bar Association, talk about how these attacks on the judiciary undermines the independence of the judiciary. How does it undermine the public's view of not just the judiciary, but the court system itself, the judicial system?
Well, I mean, I think that there's a continuum. Criticizing Judge Kiesel, I'll use her, not me, for her opinion. That's one thing. Criticizing her as not being, as being biased is another thing. Criticizing her as being a rogue judge, as if she doesn't deserve to wear the robes, is another thing entirely. And criticism that comes from government officials, as opposed to the guy on the street, is an entirely different dimension. You know, when the Vice President of the United States, who is a lawyer, criticizes a judge's opinions, not because he disagrees with the opinions, but suggesting that something about what they did and what they said and how they conducted themselves was illegitimate, that has an impact beyond just, you know, the editorial criticizing the decision-making that I engaged in or the conclusion I came to. It's very different. I mean, I think these kinds of criticisms have been like nothing we have ever seen, and they are very serious.
And it's very troubling that this idea that somehow a judge who disagrees with you is not ethical, that there's something unethical about a judge rendering a decision that doesn't go your way. And, you know, litigants filing reports with conduct committees, either in the state or on the federal level. I mean, those should be reserved for when a judge has done something truly outrageous that everyone recognizes, not that a decision doesn't go your way. And in other words, the disciplinary process has almost been cheapened, if you will, by this, and it's very disturbing.
Allegedly, there may have been government lawyers who decided they were not going to follow court orders, or may allegedly have instructed subordinates not to follow court orders. How does just that coming out publicly, how do you think that impacts just regular lay folks who are given orders by the court and their willingness to follow court orders?
I think we haven't seen it yet. We haven't seen the impact of that. I think that needs to be studied. Today, Judge Ellis in Chicago issued a 233-page decision in which she, I don't have the exact language in front of me, effectively said that a government official had lied. Now, one of two things can happen. On the one hand, the enormity of that finding could chasten people so that they do not lie in court, so that they do not misrepresent in court. I suppose the other possibility is that if that happens enough and enough judges call it out, it could make it more normal. I don't think that we're there yet. I think her language, I think that it still is, it's unusual. But for her to, and judges to call out witnesses to that degree. So we don't know the impact as yet. I don't think that making that kind of finding will be the problem. I think if we begin to see disobedience of court orders, that's when we are in true constitutional crisis, fundamental constitutional crisis.
And of course, the question will be, what happens if there is disobedience and it goes up the appellate line? At some point, is either a United States Court of Appeals or ultimately the Supreme Court going to, put a stop to it?
Right. I mean, it's very interesting. I mean, I thought that when issues get litigated in court, and that this is the way it's supposed to be, that the language and the ethical rules would be different than the things you were saying in Twitter. In other words, when issues are being bandied about on social media or in the newspapers, are very different than in court. And now sort of calling out people for violating those rules, not just those norms, but those rules in court. On the one hand, calling them out is very good and can chasten other people. On the other hand, that can normalize it. And I don't know where we are yet.
Good point.
What can we, and I use we to mean not just lawyers and former judges and bar associations, but all of us, how can we educate the public who don't know that there's something called the rules of professional responsibility for attorneys, and it is an ethical violation to intentionally disobey a court order? How do we educate the public about what's going on and the consequences of what is going on?
Well, I think we do it through the media, through writing op-ed pieces. I think we do it by having forums like this. I think we as members of the legal profession should be in colleges and high schools more often. I remember when I sat on the bench and school groups would come very often to sit and watch. I always made sure that after they watched the proceedings for a certain period of time, I took a recess. I walked down into the courtroom in my robe and I would ask them, do you have any questions? Do you know what's going on here? Is there anything I can explain? I mean, that's kind of the only way you could do it. Education sort of has to start small and grow, you know? I think our civics education in this country is pathetic.
I completely agree with you. I also think that there's stuff that has to be done now. In other words, waiting for the curriculum to percolate through the schools and in our country is not enough. We have to have programs like this. We have to have television programs. I mean, I am the only, octogenarian techie I know. I mean, I'm on all social media. If you think for a minute I know what I'm doing, I don't. But I post on Blue Sky, I post on this and that, because I think you have to meet the community where it is. And we all have to do that. So if you hear something very embarrassing suddenly turning viral on social media, it's bound to be me. But I do think, I mean, people talk about civics education, and that is clearly terribly important. But I think we're in a crisis now, and I think we have to speak about it in all of the forums in which people are listening.
It's a number of former judges, lawyers who are still correct, people on this panel have signed on to amicus briefs for different rule of law issues. And so you're saying, op-eds, briefs, is it sort of just flooding the zone everywhere we can to let the public know this is not how our judicial system is supposed to work?
I think that's really critical. As I said, when I was on the bench, which was 14 years ago was the last time I was a judge, there was a sense that you didn't have to aggressively seek to legitimate your position, because people assumed that you were deserving of respect. I think that after the attacks of the past couple of years, we have to work for it. We have to show our work. We have to show people what we're doing. We have to explain what we're doing to meet the criticisms. I like to say that when I wrote an opinion in a case, the first 3 paragraphs were like a press release. My clerks would give me something that was written in law, which is not a language that any other human being knows. And I would say, we need a press release at the beginning so people understand what I've done and why. And that was because even then I was feeling that we had to justify our existence in a way that we never had before.
And I do think we need to reach especially young people where they are. As Judge Gertner said, I am hopeless with things like Twitter and Facebook. However, podcasts are a wonderful opportunity to reach people. Young people, they talk about them all the time. They listen to them constantly. A great place to be talking about what the law is, what judges do, how the system should work.
We'll have a Kiesel Gertner podcast.
Sounds like fun. I'm there.
It's the beauty of being a retired HON. You are free agent.
Right.
You can do that. What if we're coming near the end of the program, what is the one point both of you think that we should leave with the audience? And this is recorded and hopefully will be publicized. What do you want everyone to remember about what's happening at this moment and what we can do about it?
Diane?
Well, I keep thinking about Richard Nixon lately, and there's a
I'm
connection
so sorry.
I know, there's a connection. In 1970, he opened his mouth in the middle of the Charles Manson trial and said he was guilty. And the world, you'd think, would come to an end. Every newspaper, Nixon says Manson guilty. It almost created a mistrial, and it was so out of the norm that within a few hours, even Richard Nixon walked it back. And I raise this anecdote because what it says is we have normalized somehow in our head or in the press the idea that these outrageous comments coming from the highest place in the land is somehow normal. Folks, it's not normal. And we have to do everything we can to pound that home.
Oh, I agree. I also think that there's a role for retired judges like we are to say to people, there are boundaries in the rule of law. And if we don't respect those boundaries, we will be a lawless society. We will be in danger. People have to understand the implications of not respecting the courts, the implications of not respecting a judge's decision, the implications of not respecting the independence of the judiciary, that the implications of that is autocracy, is the leader who has no boundaries, who has no limits. Right now, the courts are policing the limits of executive power, and that's as it should be. And people have to understand the importance of that. So I think that we're part of the communicators of that, and everyone should communicate it in whatever that way they can.
And trial junkie, going back to federal judges.
I think
We lost you, Catherine.
we lost your voice. We can't hear you.
Sorry about that. Am I muted? Can you hear me?
You got it. You got it. You're back.
I think I accidentally muted myself. Sorry about that. But just quickly, just going back to jurors and postings, and I'm thinking of the one earlier where the President of the United States listed people and said they're guilty as hell, quote. Would you proactively in voir dire as a judge sort of just, did you read this? Did you see this? Now, the danger, I would think, obviously, if they had, now they know about it, but would you proactively recommend doing that?
I think the best question is always, what have you read, seen, or heard? And let them describe what it is because of the danger that you just described. And you have to give some time to it. In a high profile case in which you're trying one of the targets that are in that tweet, you have to give some time, what have you read, seen, or heard in the past week, in the past month? In other words, given the social media environment, it makes voir dire, the questioning of jurors, even more significant and even more important. Federal court that I was a part of had no tradition of voir dire. One judge used to brag about how he could pick a jury in 10 minutes. I didn't think that was anything to brag about, and it certainly isn't today. So I think we have to do more on our end to find out what people have read, seen, or heard, and to recognize that we really need honest answers to that.
I don't know if we're allowed. Judge Kiesel, do you have more to add?
No.
I don't know whether or not we're allowed to take questions. If we are, someone's going to have to tell me how to do that. But if we're not, I think Judge Quince, if her boat is still afloat.
Yes,
You have some.
I am still here. And I want to really thank all of you for your important insights on the critical topics. You have left us with much to think about, and we really need to be thinking about how to make sure our judiciary stays independent. And by saying independent, I don't mean that there's no oversight, but there's a way to do it. So you've left us with much to think about, and I call on all of us to participate and join in this action. On behalf of all of us at Lawyers Defending American Democracy, thank you for attending this webinar and for your commitment to our democratic institutions. We hope that you will stay involved in addressing what is ahead and join Lawyers Defending American Democracy in this work. Please visit our website at LDAD.org and become involved in our efforts. It is going to take all of us acting together to address this critical concern with our judiciary. So again, thank you so much for being here, and thank you to our panelists for such a wonderful, wonderful discussion.
Thank you.
Thank you.